Hi, my name is John Wakefield, and on this video I'm going to be talking about what occurs at a motion to suppress. At a motion to suppress, the defense has previously filed some form of motion challenging usually the constitutionality or procedures behind something that the law enforcement has done, whether that is a search, seizure, or in regards to any sort of alleged confessions. There's going to be a motions hearing. At a motion to suppress, the prosecution will have the burden of showing that any information or any materials seized or obtained were done so lawfully and pursuant to the United States and Georgia constitutions. The judge will ask the defense and the state to present opening statements about why we're here and what's going on. It's usually the defendant's obligation to go ahead and say, Judge, we're here for X, Y, and Z. The state may make some initial opening remarks, and then the state will bring forth witnesses, almost certainly law enforcement, to back up why their evidence is admissible and is legal. The state will present their evidence. The defendant will have an opportunity to cross-examine that witness, and then so forth and so on as far as any witnesses go. The defense will also have an opportunity to present any witnesses. Generally speaking, most defense attorneys do not put the defendant up on the stand due to the defendant's right to remain silent. However, under certain circumstances that may occur. Additionally, if there are any experts, such as an expert regarding standard field sobriety tests or something along those lines, that defense expert could testify as well. After all the evidence has been presented, there will be an argument over the law of the case, meaning, hey, Judge, this certain case needs to apply, and therefore the defense wins on this issue. The prosecution will present evidence and argument basically stating, Judge, this evidence should be allowed into the trial. Many times the judge will rule right then and there from the bench. Other times, if it's a more complicated matter, the judge will take it under advisement and generally issue a ruling after about 30 days. It's important to note that whether the defendant wins or loses at a motion to suppress, the defendant always wins at least a little bit because they get a preview of the prosecution's case in the matter and get to have the arresting officer and usually other officers under oath state exactly what went on. I hope this information is helpful. Please remember this is not legal advice and is for informational purposes only. Should you have any questions or concerns, please feel free to email me or call me at any point. Thanks so much.